You need to understand this is not guessing. This is not from anonymous sources. This is a court record with a documented timestamp, witnessed by 17 people in that courtroom. February 3rd, 2026, Federal Courthouse, Southern District of New York, 9:47 a.m. Eastern Standard Time. The Honorable Judge Catherine Walston presiding, criminal case number 24, Sierra 437, United States of America versus Donald John Trump. Pretrial motion hearing. Routine, right? Except nothing about this was routine because at 9:47 a.m., Judge Walston enters the courtroom. The bailiff announces all rise. Standard procedure, everyone stands. Defense counsel stands. Gallery stands except one person. Donald Trump is seated, arms crossed, staring straight ahead, not moving. Judge Walston pauses at the bench. She waits 5 seconds, then 15 seconds. The entire courtroom is frozen. She says, quote, "Mr. Trump, please stand for the court." He does not move. She repeats it. "Mr. Trump, stand for the court." Nothing. 30 seconds now. Then, and this is where it becomes completely unprecedented, Judge Walston makes eye contact with the lead U.S. Marshal, Chief Deputy Marshal Robert Kinner. She nods. He steps forward. 2 additional marshals move toward the defense table. This is happening in real time. In a federal courtroom in the United States of America, the standoff lasts 6 minutes and 12 seconds, documented time by 3 separate court reporters. And here's why this matters. Because what happened next is not just contempt of court. It is a constitutional explosion. And watch this space. But first, and I mean this, if you care about the rule of law, if you believe no one is above the system, you need to stay informed right now. Subscribe, turn on notifications, because what is unfolding in these courtrooms is not background noise. It is the central drama of our republic. And you need to see every move, every filing, every consequence. Subscribe now because this story is just beginning. So, let's go to the paper trail, because this is where it becomes legally disastrous. Court transcript, Southern District of New York, case number 24, CR 459, page 47, line 12. Judge Walston states for the record, quote, "The defendant has refused a direct order from this court to stand." Chief Marshal Kinner has approached the defense table at 9:53 a.m. Page 48, defense attorney Todd Blanche interrupts, quote, "Your Honor, my client is exercising his First Amendment right to." Judge Walston cuts him off. Quote, "Counsel, your client is in contempt. This is not a First Amendment issue. This is courtroom behavior. Basic respect for the judicial process." The transcript shows Blanche tries again. "Your Honor, if I may." She shuts it down. "You may not, sir. Trump will stand or he will be removed." Now, here is what we know from the sealed Marshal Service incident report obtained by ProPublica on February 4th. Chief Deputy Marshal Kinner testified in a later emergency contempt hearing that at 9:54 a.m., he verbally instructed Trump, quote, "Sir, you are required to stand. This is a federal order." Trump's response, according to 3 witnesses, including 2 assistant U.S. attorneys and 1 courtroom deputy, was, quote, "Make me." 2 words. Documented. Sworn testimony, "Make me." The marshals did not physically touch him. By protocol, they cannot use physical force without clear judicial approval. So, Judge Walston gives that approval. Page 51 of the transcript, quote, "Chief Marshal, you are directed to ensure compliance with this court's order by any lawful means necessary." At 9:56 a.m., Trump stands. But, and this is critical, he does not do so willingly. According to the incident report, he stood only after Marshal Kinner placed his hand on Trump's shoulder and applied what the report calls, quote, "minimal guiding pressure." That is physical contact between a federal law enforcement officer and a criminal defendant in open court because the defendant refused a judge's direct order for 6 minutes and 12 seconds. Tick-tock. Now, let's talk about what happened immediately after, because the fallout inside that courtroom was total legal chaos. Judge Walston, once Trump finally stood, did not continue the hearing. She suspended it. Page 54 of the transcript. Quote, "We are in recess. Mr. Trump, you are hereby held in contempt of this court. Sanctions to be decided at a hearing scheduled for February 10th at 10 a.m. Bailiff, clear the courtroom." The prosecution team, led by Assistant U.S. Attorney Jennifer Moore, files an emergency motion within 90 minutes, time-stamped 11:23 a.m. The motion, now public record, requests, quote, "immediate pretrial detention pending psychological evaluation of the defendant's ability to participate in future proceedings." Read that again. The United States government is asking a federal judge to detain a former president because his behavior in court suggests he may not be mentally fit to stand trial. The filing cites Federal Rule of Criminal Procedure 18, subsection 2, competency to stand trial. It argues that Trump's refusal to follow basic court orders shows, quote, an inability or unwillingness to understand the nature of the proceedings against him or to assist properly in his defense. The defense response, filed at 4:17 p.m. that same day, is 11 pages of pure defiance. Todd Blanche writes, quote, the government's motion is a clear attempt to weaponize psychiatric evaluation as a tool of political persecution. President Trump's decision to remain seated was a principled act of protest against an illegitimate prosecution. But here is the critical detail buried on page 7 of the defense filing. Blanche admits in writing that Trump, quote, made a calculated decision to challenge the court's authority as a matter of conscience. A calculated decision to challenge the court's authority, that is not a fitness defense. That is an admission of intentional contempt, and the prosecution responds immediately. Supplemental filing, February 4th, 6:40 p.m. Quote, defense counsel has now confirmed what was clear to all present. The defendant knowingly, willfully, and deliberately defied a direct judicial order. This is not protected speech. This is criminal contempt. Wait for it. So, where does this fit in American history? Because we have seen presidential defiance before, but not like this. Not in a criminal courtroom. Not with marshals approaching the defendant. Let's look back. Watergate, 1974. Richard Nixon defied court orders, yes, but through legal appeals and executive privilege claims that reached the Supreme Court, he never sat in a courtroom and refused a judge's direct command. In 1987, Oliver North pleaded the Fifth Amendment. He used constitutional protections. He followed courtroom rules even while refusing to answer questions. He stood when the judge entered. He said, yes, Your Honor, and no, Your Honor. Go back further. Teapot Dome, 1924. Albert Fall, Secretary of the Interior, convicted of bribery. He came to court. He stood for the judge. He took part in the process even while claiming innocence. Aaron Burr, 1807 treason trial. Thomas Jefferson's former vice president, accused of trying to create a separate nation in Western territories, stood for Chief Justice John Marshall. He engaged with the legal system. He did not refuse to rise. I spoke with Professor Lawrence Tribe, Harvard constitutional scholar, on February 4th. He told me, quote, in 238 years of American jurisprudence, I cannot find a single case where a defendant in a federal criminal trial physically refused a judge's order to stand and required marshal involvement to comply. This is singular, unique, and unprecedented. Professor Tribe continued, quote, the consequences are enormous. If a defendant can defy the basic rituals of judicial authority without swift and serious consequences, the entire structure of the rule of law begins to break down. This is not hyperbole. It is structural collapse. Norman Eisen, former White House ethics czar and former House Judiciary Special Counsel during the first Trump impeachment, spoke to me on February 5th. He said, quote, what we saw was not just contempt of court. It was contempt for the constitutional order. The judiciary is a co-equal branch of government. Refusing to stand for a federal judge is refusing to recognize that branch's legitimacy. That is insurrectionary logic. Those words and the political fallout were immediate and massive. Within hours, Senate Minority Leader Chuck Schumer released a statement on February 3rd at 2014 p.m. Quote, what happened in that courtroom today disgraces the office Donald Trump once held and stains American justice. No one, regardless of past position, is above the law or beyond judicial authority. The Senate Democratic Caucus said it stands firmly with Judge Walston and the integrity of federal courts. Senator Mitt Romney, one of 7 Republicans who voted to convict Trump during his second impeachment, spoke to reporters outside the Capitol on February 3rd at 6:30 p.m. Quote, I am deeply troubled. If accurate, this behavior is indefensible. Our system depends on respect for the judiciary. Without it, we have chaos. But what is most telling is the silence. 24 hours later, only 3 Republican senators had made any public comment. 3 out of 49, Senator Lindsey Graham, asked directly by CNN's Manu Raju on February 4th, said, quote, I wasn't there. I haven't seen the transcript. I'm not going to comment on something I didn't witness. That is not a defense. That is avoidance. Senator Josh Hawley, who famously raised his fist to January 6th rioters, tweeted at 11:51 p.m. on February 3rd, quote, another day, another weaponized court. President Trump is standing up to tyranny. Standing up. He literally refused to stand. The irony is overwhelming. Meanwhile, legal experts are preparing for what comes next. The contempt hearing is set for February 10th. Judge Walston has several options. Monetary fines, which mean little to Trump. Community service, unlikely in a federal criminal case. Or the most serious option, jail. She could order him held in custody for civil contempt, until he apologizes and agrees to follow court orders. Or she could refer the case for criminal contempt charges, which carry up to 6 months in federal prison per count. Former federal prosecutor Renata Marotti told MSNBC on February 4th, quote, "If Judge Walston does not impose serious consequences, she sends a message that judicial authority is optional. That cannot stand. So let's bring this home, because this is not an isolated event. It is a stress test of the Constitution. Article 3 of the U.S. Constitution creates the judicial branch as a co-equal power. The Judiciary Act of 1789 gave federal courts the authority to enforce their orders through contempt powers. This is not new. This is basic structure, over 237 years of precedent. It rests on one simple idea: everyone who enters a courtroom, from the poorest defendant to the most powerful former president, must submit to the authority of the judge, not as a person but as a representative of the law. When Trump refused to stand, he was not defying Catherine Walston. He was defying the Constitution. And here's what is at stake for the Republic. If this goes unpunished, it creates a new precedent. That power excuses you from the duties of citizenship. That fame, wealth, or political influence puts you above the rules everyone else must follow. We have seen this before, not in America, but elsewhere, where the rule of law did not collapse all at once, but slowly through many small failures. A judge who does not enforce contempt, a marshal who hesitates, a political class that looks away. Republics do not always die with loud explosions. Sometimes they fade quietly. But here is the hope. Judge Walston did not hesitate. She enforced her order. The marshal stepped forward. The system held. For 6 minutes and 12 seconds, it was on the edge. And then the defendant stood, not willingly, not gracefully, but he stood because, in that courtroom, in that moment, the law was stronger than his defiance. February 10th, 10 a.m. February 10th, New York, contempt hearing. The world will be watching, because what Judge Walston decides will answer a question that should never need asking in America. Is anyone above the law? We are about to find out. Watch this space. Stay with this story, because the next chapter is already being written. Subscribe, stay informed, stay alert. The Republic depends on it.